That if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea. Calling 2024 CR 011624, State versus Jan Hawkins, aka Jan Madura. Can I have parties announced?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Ms. Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA as Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 1. We're proceeding on a lesser included of count 2
And what are you proceeding on?
on a Class A theft.
No objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a...
Wait, did you catch that the judge just made it crystal clear a plea deal is not a guarantee even if both sides agree the court can completely reject it? So the real question is this deal solid or already falling apart behind the scenes?
Plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred before a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
Right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out all. We're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here?
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may, we've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provide purpose, having us do. We've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate her no. She's pleading no contest, and so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea.
Now this is where things get messy. A no contest plea usually means you're not fighting the charges, but here, the defense is trying to cherry pick what they agree with. Legally? That's risky. Because if you don't stipulate to the evidence, you're basically challenging the entire case. And the judge is not having it.
I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented, and then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have, at the very
That's why you have, nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well, that's where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this. If she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then
amount.
you all need to change your paper.
And Your Honor, I know to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence, and the judge can look at that and decide that they find those documents credible and find that they are true.
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you accept if we just simply put on that we do not stipulate to the final amount?
Y'all do the paperwork, and if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the thing. I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that, and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge. Okay, thank you.
Yes. Court is calling 2025 CR 015632, State versus Christopher Polito. Could I have parties announced?
Here comes from Mr. Polito.
And are you Mr. Polito? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Polito, did you review the application for community supervision with your attorney? Did you understand it? And did you sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Yes, Your Honor. Ms. Polito, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years into prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. All right. Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Polito, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine, and the state is opposed to your application. Did you understand that to be the plea?
Yes.
Defense?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Mr. Investigator states.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. What is his criminal history?
State theft as well as conviction for burglary of ability and possession of D1 weapon. 2 felonies were referred.
Okay. All right. Are you waiving PSI?
We can, the state's opposed, but we can.
Well, now my question is, are you waiving PSI?
If you want to make a decision, maybe we want to wait 30 days. We waive the PSI, Judge.
All right. And state you're opposed, and why are you opposed?
From this judge, we are opposed. Mr. Polito was placed on probation in 2023 as well as that drug conviction in 2023, and then picked up this new case. So he's already done a trip to TTC on that one before brings me.
All right. Thank you. So why were you revoked on your last probation? What did you not do?
Report.
Okay. And how often have you been using drugs?
26.
And what have you been using?
Marijuana at first, and then it went to cocaine, then cocaine went to meth, and then I started drinking, and then I just stayed on meth.
And do you have any children? What are their ages?
15, she lives in Austin. 2 live right now with my parents, and a 7 and 8-year-old, and then I have a 3-year-old.
All right. So here's the thing. I'm going to give you a choice. There are no other choices. Don't ask me for a third option. Either choice that you make is going to result in you being in custody. First choice, I'll find you guilty, as I already have done. Sentence you to prison for 5 years. Next choice, I'll grant your application, and I will sentence you to 6 years in the prison, suspended and probated for 8 years. But you're going to remain in custody. You're going to be referred to felony drug court. If they do not accept you, you're going to be going into inpatient treatment somewhere. So those are your only options. And the only reason why I'm giving you these options is because sometimes it's not good to kick the can down the road. You have these children who are depending on you for support. And one or two things going to end up happening if you don't get treatment. Either you're going to end up in prison for the rest of your life, or either somebody's going to end up identifying your body.
This is the moment everything shifts. It's no longer just about punishment, it's about survival. The judge is laying out 2 brutal realities, prison or a strict path to redemption. And notice the strategy here, this isn't just sentencing, it's pressure with purpose. The real question is, will he actually change or end up right back in this courtroom?
So, which do you prefer? 5 years in the prison, or either you remain in custody until you're accepted in felony drug court, or either into an inpatient drug treatment? right, thank you, counsel. All right, this is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 8 years. The following is to take place in custody: a referral to felony drug court, TAP evaluation. If not accepted into felony drug court, then inpatient treatment. And that inpatient treatment, probation, if TAP evaluation approves, will be SafeP. There's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month until further notice upon release from custody. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are complete, 50 hours will be deducted. The remaining community service hours, you can either do 150 in the heat, which it's going to get hot pretty soon, or there's going to be for every sober support meeting completed, that's your AANA meetings, 1 hour of community service restitution will be deducted. There's to be no unsupervised contact with minors. That may change once you prove to the court that you can be clean and sober. There is to be a $1,200 fine. That will be probated. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You have children who are depending on you 100%. If you continue the way you're going, some other man is going to end up raising your children, because either you're going to end up spending the majority of your time at the Bexar County Jail or in prison, or either somebody's going to have to identify your body, because the last time you use may be the last time you use. In this court, communication is key to be successful. Talk to your probation officer. If you ever feel like, once you've completed the inpatient program you're going to use, call your sponsor, call probation. If you call probation and you tell them that you're thinking about using, you know what they're going to do? They're going to get you some help. If you come in here and talk to me and say, Judge, I'm struggling, I think I'm going to use, guess what I'm going to do? I'm going to get you some help. But if you don't report, we're going to have a problem. You understand? All right, good luck to you.